Sabri, I mean, one of respondents' arguments is that those cases are different because the federal government's interest in funding was more directly involved, that what they really were all about was ensuring that the federal government could make sure that the recipient didn't fritter away the federal government's own funds. So why is that true or not true?
Yeah, so we would strongly resist that RLUIPA isn't about protecting federal funds. It absolutely is. The federal government gives money to prisons, to state prisons, on the condition that they won't violate religious free exercise. When they do that anyway, the government is not getting what it pays for, which is institutions that respect religious exercise. So I do think that this is about protecting the funds. I'll also say that in Salinas and Sabri, the court was concerned about more than just protection of the actual funds at issue, and I think you can see this because neither case required any nexus with the federal funds. It's most obvious in Salinas, where the court there described the threat to the federal program was the deputy sheriff who was giving preferential treatment to the inmate. It was clear as day that that was the threat that the court was talking about. And I think here the federal program is similarly threatened when officers can violate conditions on federal funds with impunity.
So in those cases, what the court was really saying is that the federal government has every right to deal only with institutions that are not generally corrupt. And here it's the same, except the end of the sentence would be not generally rights violating.
I think that's right, Justice Kagan. The federal government does not want to be a party to egregious violations of religious liberty like the facts alleged in this case. I mean, the federal government has the power when it says it's giving federal funds on the condition to enforce that condition, and the state can always say no.
Thank you.
Justice Gorsuch.